Welcome, everybody. This is the session on changing face of diversity in the legal profession, part of the Alumni Festival in Cambridge in 2021, along with the Cambridge Women in Law. My name is Pippa Rogerson, and with me here in Lady Mitchell Hall are Lady Brenda Hale, Tolu Mustapha, and Julia Freytag. Lady Hale needs no introduction, but I will give her one anyway. She's past president of the Supreme Court, and maybe one of her most notable cases is the Gina Miller case. An alumna of Girton College, past law commissioner, member of the law faculty in Manchester, and my particular favourite, a recent star of Desert Island Discs. And I have to confess that the Bach B minor Gloria would also be my go-to disc, perhaps singing rather than conducting. Tolu is a third-year law student at Fitzwilliam who is entering the solicitor's profession, and Julia just completing her MPhil in criminology and hoping to enter and go on to the bar. For me, I'm a reader in the law faculty and also master of Gonville and Caius College. The outline of this session today is that we'll have up to 4:30 with some discussion and questions in the room. And then there should be some time for questions from the audience. So please use the chat function in Zoom to give us your questions, and we'll have about 20 minutes to continue that discussion with you after 4:30. So let's get started. Tolu, I think you have the first question.
Yes, so as lawyers and law students, we're probably quite familiar with defining key terms. The first question that I wanted to ask is, what does diversity mean to you? And in the context of the legal profession, what do you think it should mean?
Well, it's easier to answer what I think it should mean, because whether it does mean that in the legal profession, we might discuss a little bit more about later on. But I think that diversity should mean that the legal profession is full of all sorts of different people, not just pale male people. So lots of women, lots of people of colour, lots of people from different religions and beliefs, disabled people, lots of people from different socioeconomic backgrounds. And with that sort of mix of people, we could expect the legal profession to be able to serve the people that it is supposed to serve, the people and the businesses it's supposed to serve. When I say people, I also like to include businesses, enterprises, organisations, because it's there to serve all of those as well, much better than it would do if all it was doing was being pale males trying to serve all sorts of people and businesses that it's much more difficult to understand.
I mean, it's quite interesting, isn't it, that the notion of diversity has changed quite a lot, I think, over yours and my lifetime, Brenda, which is it was originally very focused on women, but it's now a much broader and more interesting discussion, I think, of inclusion and diversity, as exactly as you say, to try and ensure that the reflection of experience and understanding and need of wider society is there in the legal profession.
I don't want to diminish the importance of gender, because after all, we are half the human race. And so if we're not at least 40% represented, and preferably at 50 to 60, well then we're not being properly represented. So I don't want to diminish that while thinking there are so many other dimensions to diversity.
Yes, and of course the intersectional argument I think we all absolutely understand.
Absolutely true, but could I just add to that? You mentioned inclusion. And I think one of the most important things about a diversity agenda is that it's not just we want to embrace difference, we want to make ourselves available to all sorts of different people. Actually, you can only do that properly if you include them. In other words, you have a workplace, an environment which is genuinely welcoming to people who are different from the stereotype. And that's much harder to do, because that's all about mainstreaming it, isn't it? And it's all about saying, we think that a diverse workplace is a good thing, and in fact it's an essential thing. It's not just nice to have, it's an essential. So I want to get all that out there.
Yeah. Well, I think we can all around this table agree on that, and I hope we'll have some more discussion later. So, shall we move on to looking back a little bit? I was in the first cohort of 50% entering the Law Society. Now, that is back in the dark ages. This was 1984. 50% of my cohort entering the solicitor's profession were women. And yet here we are 35 years later, 36 years later, and still we don't see 50% of women partners, for example. Why do we think this is still the case? Julia, you had a question you wanted to ask about this.
So I suppose it leads on very well from what we've just been talking about, but why is it the case that those from disadvantaged backgrounds and ethnic minorities continue to this day to still be so underrepresented, but particularly at the bar?
Do you know, I have a feeling you might know the answer to that better than I do. The bar is a particularly hard nut to crack, because in order to qualify as a barrister, you have to do a pupillage. And pupillage recruitment, however hard they try, is limited by the number of pupillages available. And if we expect just the self-employed chambers-based practitioners to offer pupillages, they're not going to offer enough pupillages for all the people who want to qualify as barristers. It's just not going to happen, which is why so very many aspiring young barristers spend all the money getting the degree, doing the conversion course if they haven't got a law degree, doing the bar professional training course, and then finding there isn't a pupillage. So we've got to think, well, why all this focus on the chambers-based practitioners to provide the training? Because the bar is a qualification that you can use in so many different ways. It's not all about turning into the next great advocate, is it? It's about so many different things. And so we have to look to a lot of other places to try and provide pupillages. And then those who have the ability and the desire to do it can at least get their feet onto the bottom rung of the ladder, which is actually being called to the bar. So again, part of my diversity and inclusion thing is thinking we're so focused, especially at the bar, on the self-employed chambers practitioners. But even in the solicitor's profession, we are focused on the solicitors' firms, when in fact there's loads of law practice going on in other places, loads of it. And a lot of it very exciting and interesting law practice. 60% of in-house counsel of all kinds are women. That's a very interesting statistic, isn't it? But you've got to get your foot on the bottom rung of the training contract, or although these are slightly changing for solicitors through the SQE changes. So, and maybe the bar is also looking at it, but it is, I think, what you say is important, that we have ways in which we can qualify, all of us, lawyers who want to qualify, and then to be able to find our own route into how we need to practice law. And it's true that in-house counsel and other sorts of practice of law are just as valuable and helpful, and maybe more flexible, which I suppose is something which might keep people in the profession who might otherwise not be. So would we say that that's then something for the regulators, the Solicitors Regulatory Authority, the Law Society, the Bar Council, or whoever, who need to think about those routes of entry into the profession? Of course, we might actually have to ask ourselves down the road, why do we still have a divided legal profession? And if we do still have a divided legal profession, and I can understand all the arguments why we should, why don't we nevertheless have one route in? and a specialisation at a much later stage, rather than, on the whole, it's taking a shorter time to practice as a barrister, to qualify as a barrister than as a solicitor, which is a bit of an incentive to the people who want to do it. And the bar's still got this great glamour attraction to it, hasn't it? I'm afraid, which means that some people want to qualify as barristers, even though, with a view to becoming a certain sort of practitioner, even though that is not going to happen for a large proportion of them. So why don't we all qualify as professional lawyers by one route and then work out whether a particular type of practice is the one for you at a later stage?
That would be quite a radical change, but the benefits might be great in terms of diversity and flexibility, perhaps.
I think the benefits might be great anyway. But for diversity and inclusion, they would undoubtedly be great.
I think that leads quite nicely onto your question, Tolu, really.
Yes, definitely. So as we've discussed, aspiring barristers go through the bar course. They often incur a significant amount of debt and might not even get a pupillage at the end of it. For aspiring solicitors, they'd have to rely on firms often to fund the LPC, the legal practice course, or the new SQE. But due to competition, not everyone gets training contracts. So what do you think that the legal profession could do to ensure that finance isn't a barrier to encouraging more diversity in the profession?
Well, we've talked a bit about it already, haven't we, in broadening the range of organisations that offer training contracts and pupillages. But it's also essential, isn't it, for the profession to see that bringing on the next generation of practitioners is vital for the profession, rather than thinking, well, I've got there, I've succeeded, how wonderful, up with the drawbridge, etc. No, if we want a legal profession which is going to be fit to serve the people whom it's supposed to be serving, like I said earlier, the profession has got to embrace the idea that it's their business to ensure that there are enough new people coming into the profession. Do you know, I'm beginning to think there's an analogy with truckers here.
Yes, who's queuing for their petrol station even as we speak? So I think let's move from finance then through to a question, Julia, that you had. This is particularly about the bar, but what would you like to ask?
So I think we've looked at very much how this traditional understanding and that separation between solicitor and barrister is very historical. And I wanted to ask that, do you think that this traditional idea of what being at the bar entails and what being a solicitor entails, but perhaps my question is more geared towards the bar, do you think that question that experience affects those from disadvantaged backgrounds trying to fit into this more traditional way of what they believe a barrister should be or how a barrister should act, or I suppose you can extend it to a solicitor, but are we trapped in this idea of traditionalism?
It doesn't seem to put a lot of people off. I mean, what strikes me, I meet an awful lot of young people who are aspiring to become legal practitioners of one sort or the other. And I am amazed at the way in which they are enthusiastically hoping to become lawyers. After all, we have all of these universities now. They've all got a law school, almost all of them. And we have plenty of people who don't have law degrees, still want to become lawyers. It's costing loads of money, but they still seem to want to do it. And then they want, obviously, to qualify. So I'm not sure that traditional stereotypical views about what it's like to be a barrister or a solicitor are actually putting people off then. Maybe it does at a later stage when you encounter what it's really like. Because isn't it a problem for all of us who, even me, come from non-typical, because the typical is white male, okay? So all of us from non-white male backgrounds, existences, we've always got this problem. Do I try and behave like them? Or do I try and be me? And I think that's something that we all have to. But then I actually think that we should be us. And that's what inclusion's all about. Inclusion is about safe spaces for different sorts of people to operate in their way, not necessarily in the way of the traditional people. And I come back to Cambridge. When the men's colleges first admitted women, I don't know about Keys, so I'm not going to say anything about Keys, but I do know about other colleges where it was taken for granted that the women who wanted to go to a man's college would just have to put up with what the men had to put up with. Now, that's not right.
No.
You know, if you admit different sorts of people, you know, you have to change your ways in order to make it a friendly, inclusive, workable place for those people. And I think that's true of the professions as well. I mean, not just the legal profession, the other professions as well.
Well, it's sort of part of the point. If we value diversity and representation for what it brings for these important matters of things like representation and different experience and how that adds to the good quality of the decisions and other things that are being made, to have people come in and cloak themselves in what is the establishment way of doing things is really rather missing the point, it's always seemed to me. But it does seem to be quite a difficult nut to crack, because I think, Julia, you were going to ask about how some sorts of work are still reserved or seem to be reserved for certain sorts of people.
Yeah. So notwithstanding the challenges even of getting into both the solicitor profession and the bar, when progressing through the profession, even when women, for example, now are more represented at the bar than ever before, one hears that some types of work are still reserved for an elite of white men. Although women have managed to gain access to the profession, many of them are hindered by not having access to certain types of work. I note this is particularly acute for example, in criminal cases, 85% of all the high-paying fraud work goes to men and not to women. So how do we deal with this issue of, once we've sort of got people on the first rung of the ladder, as we've spoken about, how do we then ensure that there is that equality going through to the higher parts of the work, or the better paid work, or even just a different diversity of work?
Yes, well, I didn't know the figure about the criminal fraud cases. Oh, poor little women, they can't do the figures. Is that what it is? No? Or I don't know why that should be. I did also read a study of briefing practices in employment cases, which worried me much more in a way, because employment is one of those areas which traditionally women are supposed to be good at and interested in, and there are loads of them about, loads of able women. And even so, there were discriminatory briefing practices, fairly obviously. Well, this is down to the solicitors, isn't it? I'm afraid. Why are they doing it? I can't believe that it's only the men who are any good at doing fraud cases. I find that very, very difficult to believe, because I don't actually believe that only the men are good at anything, really.
No, it is interesting, and that maybe the discriminatory practices, we have to look inside ourselves to make sure, I mean, as a solicitor, not that I've done any work in the solicitor's profession for a long time, but when you choose who to brief, that you're very careful that you're not being indirectly discriminatory, or your own unconscious bias is coming to the fore in seeking advisors. And the sort of diversity successes are very uneven, aren't they? So you were talking about employment, and I'd say employment or family law, both in the professions and probably in the decision-making judicial side, whether it's tribunals or whatever. You see more women represented, and I'm not entirely sure I could unpack why that is the case, and perhaps the High Court or corporate work is quite the same. Do you have the same experience?
Well, there certainly are more women in employment and family law, and at senior successful levels in both of those, which is why I was particularly bothered by that study that nevertheless demonstrated that some of the highest quality work was being differentially. But that was alongside a study of attempts to have non-discriminatory briefing practices in the big firms, so which obviously showed some success. But even in family law, there is certainly was, big tendency for the money work, the big money work, not the everyday money work, but the big money work in particular, to go to the men, to call them the money boys and the children girls, basically. And it's still quite remarkable that that distinction in family law at the bar is visible. I think it's less than it was, obviously, because one finds that most of these distinctions are diminishing quite rapidly. And if that's the case with areas that you'd think would be well populated by successful women, you might think that it would be even worse in certain other areas of the law. And then I look at the technology and construction court, and that's full of women. And you would actually think that builders' law might be something that, the women wouldn't be so successful at. But
so there's a success. Let's all go into technology and construction work, which is also big money as far as I remember it.
Well, it's comparatively big money, yes. Yeah.
Should we move to sort of representation? And one of my favourite quotes of Caitlin Moran is, "You can't be what you can't see." And that therefore representation, we were talking earlier about bringing your whole self to work, and that's an important part of diversity. And I think it's always, in my experience, it's always helped when there have been other women in the room, and I don't feel I'm the only one at the bottom of the table, as it were. So, Tolu, I think you were going to ask a question about this.
Yeah, so today we're obviously talking about the changing face of diversity, which focuses quite a lot on representation. Sometimes it feels like there is a hyper-focus on representation when talking about diversity. So do you think that representation is the most important measure of how diverse the profession is?
Well, it's obviously an important measure, isn't it? I mean, you do need to see. I think that's what we mean by representation, isn't it? We need to see different sorts of people, and that is very important. Young people coming into a room, they need to feel there are people like them, who look like them, in the room as well. So it is an important feature. But it's not the only feature, and coming back to it, it's making people feel comfortable in the room. Not just visible, but comfortable. Workplace should be a safe space where people do feel involved, included, welcomed, able to speak out if there are things going on that they don't like. Well, maybe be told that there's no option, you may not like it, but actually this is why it is how it is. Or to be told, oh right, well we never thought of that. And that's often the case. It's just it hasn't crossed people's minds that there might be a different way of doing things, different way of talking to people, different way of talking about people. So it has to be a safe space where you can speak up, where you're not comfortable with things that are going on.
So representation is not enough in that case.
Exactly.
It has to go hand in hand, does it? I mean, I think this is not a rhetorical question. It does have to go hand in hand with a real emphasis on listening and the inclusion part as well as the diversity part. Tommy, was there a follow-up you wanted to ask, or do you think it's been answered?
I think on the point of what you've been said, especially you, Pippa, how if there are other women in the room, you might feel more confident or comfortable. What does someone do if they don't feel represented in an organisation or in the legal profession? How do they navigate that so that they can feel comfortable and excel in that situation?
Well, that's really difficult, isn't it? Because everywhere there ought to be somebody or some place you can go if you don't. There ought to be. And one always hopes that there will be. I mean, but you're never sure that there are, I'm afraid. I mean, that's why we set up the UK Association of Women Judges. Now, you'd think when people become judges, they're senior enough and confident enough and skillful enough to feel comfortable. But actually, there were quite a lot of women judges who didn't feel comfortable. They might very well be the only woman in a court centre where everybody else was man. And it wasn't that the men were deliberately unpleasant or cruel or whatever, they just didn't provide an environment where the women always felt safe. So to have somewhere where you can go at least to let your hair down and be given a few tips about what to do, because the more people there are who've been in the same situation, the more tips you can do. But every organisation ought to have places where people can go to discuss these things, shouldn't they? I think universities are probably better than anywhere else at this, but I don't...
Well, it's sort of self-help organisation sometimes, so yes. That's what you fall back on unless somebody puts structures in place. And sometimes it's quite uncomfortable to be the person who is speaking out or calling out, as we might describe it, or actively supporting other people. I mean,
yes.
Is it possible, have you found it possible, because you have been quite outspoken, Brenda, have you ever had any fear that it could be career limiting to stand up for what you think is right?
I think it probably was career limiting at certain points, probably. But it shouldn't be now. I mean, life is very different. And one of the reasons why I did begin to speak up such a lot when I got very senior was I thought to myself, well, I can't be accused of being self-interested in this now. I am one of the most senior women in the judicial profession. And if I don't speak up, a lot of the other women will feel it more difficult to speak up because they will be accused of being self-interested, or they'll feel that it will be career, either way, yes. And so that's one of the reasons why I have been so vocal about it, yes. Because somebody's got to be, and however irritating it is for the rest of the world, it's got to happen.
Well, I certainly feel personal gratitude that women ahead of me up the ladder have been prepared to be outspoken, and so I do try now, when I'm in a certain more position of power than perhaps I have been in the past, also to support other people further down the ladder. I think that's a responsibility that we should take. And I hope you're right that it is no longer a career limiting.
Well, I don't know that it is. It is no longer, but I hope so too. But I also agree about that's why I mentioned the UK Association of Women Judges. You might think self-help organisations are quite important. So there are quite a few groups now which are there to support people who feel that maybe, the great big support group for the traditionally advantaged is out there. They don't need one. My daughter, who's a great diversity and inclusion speaker in the financial sector, said, things like role models, which is representation, isn't it? Other people in the room, mentoring, and all of these, buddying, which is a slightly different thing. All of these things are essential for people who come from non-traditional backgrounds. But they're not special measures, because men have had them all the time. They just haven't had to say, we need role models, because there are plenty. They haven't had to say we need sponsorship, because there's plenty. Haven't had to say we need mentors, because there's plenty. And so we shouldn't feel in the slightest bit worried or ashamed or apologetic about trying to organise these for other groups of people.
Well, we're coming to the point where we can have some questions from the audience. I think we've covered mentoring, championing. I think we've covered various aspects of what it's like to be diverse and what the profession should do about it. So the first question we've got is from somebody, I don't think we've got a name from it, we don't have to have a name, but it's a question that socioeconomic background or social origin is a protected characteristic under the ECHR, but not under our Equalities Act. This means it's the only protected characteristic that the UK legal industry and its recruitment can directly discriminate against. Do you think correcting that issue would help unlock the social mobility problems of the legal industry?
There is a place for equality legislation. It has produced some enormous benefits. I think particularly in the gender and ethnic minority areas. But too great a proliferation of protected characteristics can provide its own difficulties, particularly when they clash with one another, which they quite frequently. One of the biggest difficulties with equality legislation is when you've got two protected characteristics that are in opposition to one another. So I'm not sure that is the answer. I just think the widening of opportunities and really careful thought about unconscious bias in selection processes are important things. Unconscious bias training gets a lot of stick, doesn't it? And yet, what's wrong with being asked to think about whether you make assumptions about merit, which may not be completely justified assumptions? Now, I don't know whether we're here in a Cambridge audience, but when I was treasurer of Gray's Inn and I was sort of looking at the criteria for awarding scholarships at Gray's Inn, one of the things that the people it was suggested that they might look out for was a good degree from a Russell Group university. So I did point out that discriminating in favour of Russell Group universities brought with it built-in socioeconomic discrimination the other way, because of the way in which the Russell Group universities' recruitment practices actually result in far more people from privately educated people from professional backgrounds being admitted to Russell Group universities. And so you are building in, just by doing that, you are building in a discriminatory factor. And you don't have to. Other universities are available. Other good degrees are available.
Other good degrees are available. And you say something very interesting about unconscious bias training, because it does have a bad reputation, or people bridle at the thought that they might need it, often the very people who do need it. And we can all, I think, be asked to challenge our own assumptions about what good looks like, and to really ensure that we focus on that. I think for myself, my slight concern about socioeconomic disadvantage is a boring lawyer's definitional one, which is rather like the elephant. We recognise it when it walks past us, but perhaps it's much more difficult to really pin it down, and then we come across the sort of conflicts and gaps that you were suggesting with the other matters.
I think also the issue that some people have with unconscious bias training is that it is unconscious, so you don't really think about it, which is why sometimes there is a need for more concrete barriers to avoid that kind of discrimination, especially when the training might not be enough, or it might not be thorough enough to actually deal with the root issue.
Yeah. Well, we're getting some more questions, so please keep them coming in. So Priya has said, role modelling, mentoring, support is so important. I think we can all agree about that. So a follow-on question, how can change be encouraged and achieved? So what values can be promoted, and how is that holding some places back?
That's quite a difficult question to answer, isn't it? It's rather a broad question. And we think we all know on this platform, don't we, what the values should be, because I think we're all agreed. We might not be entirely agreed about what the right solutions are, but we're certainly agreed about what the values should be. And that's a point that the Justice report on diversity in the judiciary and the follow-up report, which is quite recent, made, which was that organisations really need to embrace diversity and inclusion as essential parts of their mission statement, as opposed to nice to have, or worse still, got to have because the law tells us we've got to have it, which is always puts people on the defensive, whereas it ought to be embraced as something which is going to be good for the organisation. You're going to be a better organisation, you're going to do better business, you're going to serve your clients better if you yourself are a more diverse and inclusive organisation. So it's those are the values. I've said that several times, but that's all right. I'll say it many, many more times.
Well, I agree. I think sometimes the articulation of the benefits of diversity cannot be overdone, actually. People seem to forget that it is good for business, for the way in which we work, for the way in which organisations work, and along with that comes all the rest of it, really.
I think we ought to have had a man on this panel.
It's the Cambridge Women Lawyers Group. So,
even so.
So somebody else is suggesting that when she matriculated in Girton in 1969, a little bit after you?
6 years after me.
Yes. Women were vastly outnumbered by men in the university, and the questioner suspects that this was a useful preparation for later life because being the only woman in a room of men was not unusual.
That's right.
I rather feel the same. I got a bit toughened up. We were 30% when I think I started at Cambridge. But
no, that's absolutely right. In many ways, the fact that there were only 3 women's colleges, 21 men's colleges, and all the colleges were single sex, when I was here, meant you just got used to walking into a room full of men. You got used to being the only a woman in the room, which was a preparation for later life, which is much harder now. when education and at the beginning of life, things are better. And this is also true, isn't it, for ethnic minorities? Things are much better at that stage. It's just when you get into certain other rooms that you walk into and you suddenly find, you're in a boardroom and you're the only woman in a boardroom. You're in a partners meeting, you're the only woman partner.
I think some of my colleagues have also said that in some sense too, that the discrimination and lack of welcome is much more hidden. It was perhaps much more open and apparent to us, which is perhaps easier to deal with in a way, but that's a discussion maybe for another time. So we have another question here. What initiatives should be given priority in promoting diversity? Lady Hale was a pioneer, and what struggles did you have to face? So I suppose those are 2 questions really. What initiatives should be given priority? And maybe your experience of the struggles will articulate them.
I think you should ask Tolu and Julia what initiatives should be given priority. What would they like to see, the world of the legal profession doing, which it doesn't do now, to make it a more welcoming place, or a properly welcoming place. I don't want to say it's not welcoming, make it a properly welcoming place. What do you think should be done?
I think to start with, we did speak about how there is aspiration to enter into the legal profession, but while there's aspiration that it might not be as accessible to some people, often you say, oh, you have to raise this amount of money to take this course to become a lawyer, and it seems quite clear, but that amount of money is a lot, and it's kind of offering different routes into the career. That means if you can't come up with the money or it's difficult to you, you're not just left to your own devices or completely put off the profession because you can't afford it. So I think fostering that aspiration and encouraging it, but also giving people clear routes into the profession that looks at different challenges that they might face when aspiring to it.
Money.
I think in one word, that was my view. It's the money, because money speaks and money supports, and money is also a very positive signal that an employer, the profession, whatever, is really going to put its money where its mouth is in promoting these sorts of initiatives. What about you, Julia? What do you think?
No, I certainly agree that the money aspect's really important, but I think it comes back to when we talk about mentoring. I've personally found it very difficult to be able to just reach out to people and say, hello, do you have time? Can you mentor me? And so perhaps a proliferation of the mentoringships that exist, and also an appreciation of people who have got mentors. They do tend to have more refined applications. They understand the process better. And it's, I suppose, a real gentle balance between someone being proactive and looking for a mentor and reaching out and asking people. So giving people that courage to ask and not feeling bad that if that person is too busy, which, I mean, my experience of the bar is many barristers are very, very busy and they struggle to give up some of their time. But those that have done that, the benefits are unbelievable. I mean, I recently got myself a mentor, and that has helped me so much more in how I sort of both deal with the profession moving forward in my applications, but also as an advocate and figuring out, are there more diverse ways into this profession? What else can I use my advocacy skills for? Because I think as much as we must diversify the routes to qualification, and I agree with you, perhaps we could get to a point where people just become lawyers and then we specialise moving forward, might be more cohesive. I think we still struggle to get to that point where people, if they've trained as a lawyer, they think they have to only be a lawyer. There are so many other things people can do. There are skills that could be harnessed. But for those who do want to be lawyers, a lot end up not being that, becoming lawyers, because they simply don't have anyone to talk to. They don't have anyone to reach out to. It's not only expensive, but it's also demoralising, it's particularly the pupillage process. I think we often take for granted how tough that can be when something is so competitive and so difficult. You're constantly being told you're not good enough. And chambers need to understand the effect that that will have on individuals, because it is tough. And I know it's a test of resilience, but it's very much, we need to treat people like human beings going through a very difficult process. And that comes from more compassion from chambers and also from more mentorship opportunities.
Yes, taking responsibility for mentoring and helping out. We've got some interesting questions coming through, actually. So there's a question that ties into something you said earlier, Brenda, actually, is that some of the other legal professions, the legal executives, trademark attorneys, and we were also talking about those who've gone in-house counsel, seem to do much better on diversity than the bar or solicitors profession, although arguably these others don't have quite the same recognition or status. Do we, as a panel, have any comments on why this might be, or is there anything we can learn from that, or do we think? We're returning maybe to our initial thought that a single route into the profession might be the way. Yeah. And you know, the legal, as I said, the solicitor's qualification exam is trying to help some of that, but do you have anything else that you'd want to add to a very interesting observation, I think, that maybe the profession more, the older, more staid members of the profession can think of learning from how in-house counsel and Silex and the trademark attorneys have done?
There's a big thing about status, isn't there? I'm afraid. I mean, one of the reasons for floating the far from radical suggestion that we should have a single route into at least that section of the legal profession which is currently occupied by the bar and solicitors is that there is still something of the great British class system around. It does have to be mentioned, doesn't it? You know, but my husband used to say that he was only a humble attorney. He wasn't, of course, humble at all, but it was all part of his recognition that as a solicitor of a certain generation, he was aware of having been looked down on by barristers.
Well, even my experience a bit later, I would say, I certainly felt that we were the second-class profession, and I can only think that others in other parts may have felt worse.
And it's wrong. It is simply wrong. And that's one reason why everybody who goes to the bar ought to have spent time in solicitors' firms first.
There's an interesting point. Somebody else has asked, and this is, I think, a question that will be, or a comment that will be common to many of us. How much do we think that the lack of female partners in law firms and high-ranking female barristers is due to women stepping back after having a family? So how can we tackle this? We need a much more radical change in how law firms are run and in client expectations and in support from our partners, i.e. a greater expectation that we could have men as well, they say 50% more of the childcare. I think this is known as to be a default parent. And for this not to be unusual or remarkable. I don't know how we achieve that. Change is certainly something we need. Has anybody got any ideas as to how we achieve that change?
I think it's certainly the case that a reason, I'm not sure it's the only reason, but a reason for the attrition at the senior ranks of the bar and equity partners in solicitors are women who, I think, step sideways often. You know, they don't give up. They may take some time off, but they don't give up. And that's why so many of them are now in-house counsel, because that is a more manageable career and a very satisfying career. I mean, it's not one that should be regarded as a second-class career, because it's obviously very satisfying. But it isn't as visible, and it isn't regarded as being at the top. Whereas, I don't know, if you're General Counsel to the Bank of England, I think you're at the top of your game. You know, there are loads, you know, if you are the Chief Legal Advisor to the Financial Conduct Authority, I think that's a big job. You know, so it's just as important as, I keep banging on about this because I think it's so very, very important that we should recognise that. Nevertheless, of course, all those lovely young men who say, yes, I would love to have equal sharing, parenting, that's what I think should happen, yes. And you talk to people of your generation, that's what they say. It doesn't happen, and that's because of the expectations that are put on them by higher up. You know, it's all right for a woman to sort of step back a bit. It'll damage her career, but it's all right. But it's not all right for a man. So, you know, the people higher up have got to think about that.
Yes, we come back to unconscious bias and the sort of assumptions we make about the roles people should play in their own private life as well as in work.
And also the perception in some places that if you do want to work flexibly, if you do want to take a little bit, you know, wait 4 days a week, you know, or whatever, you're not as committed. Now, this is ridiculous. You can be just as committed for a shorter proportion of your time as you are if you're there all the time. In fact, being there all the time is not necessarily proof that you are really committed or really good or functioning at a very high level. This is the presenteeism thing, you know. And I hear so many stories about that still, which is very worrying.
Yeah. No, I think change happens slowly, and I certainly put it in the hands of Tolu and Julia and their generation to make sure that it does happen, because it must happen. Now, we're coming to the end of our session this afternoon. Thank you all very much for attending, and thank you for your great questions. Thank you in particular to Lady Hale, Brenda, for coming and talking to us this afternoon. I was at the first Cambridge Women in Law Day that we had a little bit over here in the law faculty, which was one of my best, most memorable occasions in Cambridge, actually. It was a day full of excitement and joy and interest and support. And we're continuing that in the remote way today. So thank you for doing that. To Julia and Tolu for your questions, to the technical team here. Thank you all, and goodbye from us.